We might get underway. Good morning, everyone, and welcome to this seminar from wherever it is that you're joining us this morning. My name is Liam Cavell, and together with Susanna Ford and Bridget Little, I'll be presenting today's session. Employee fraud and economic crime are topics that we're frequently called upon to advise, but with many organisations responding to the unfortunate situation with COVID at the moment by asking employees to work remotely, we expect that, that these sorts of issues may arise more frequently in the future. And that's because the structures, the mechanisms that organisations have in place to try and prevent this sort of conduct may have broken down in the transition to working from home. When you discover that an employee has engaged in this sort of conduct, someone that you know, that you work with, that you trust, it's often quite a shocking experience. And adding to that, compounding that shock, is the pressure to respond quickly. But what do you do? Do you call the police? Do you investigate the matter yourself? Do you fire the employee? These are questions that we're going to try and answer in this seminar, to try and talk you through the process that you should follow when faced with this sort of situation. Before I begin, I'd like to introduce my co-presenters, Susanna Ford, who's a partner in the dispute resolution and litigation team, and Bridget Little, who's the head of our workplace advisory practice.
Thanks very much, Liam. I'm Susanna, and welcome everyone. We're great to have you with us this morning. As Liam's been saying, living with COVID's provided a fertile environment for fraud and financial crime, as well as viruses. And so we're all currently living with new ways of working, having to shift resources around, dealing with the challenges that COVID is posing to our various different business models, and having to look at how we effectively deal with compliance in that environment, with the difficulties in assessing different types of external and internal risks to our various different organisations. As Liam says, I'm a litigator, so part of my practice does involve getting involved with organisations as they start investigating internal fraud or financial crime, and in doing so I work closely with Bridget, Liam and others. And most of the focus of today's presentation is going to be on a proactive approach to dealing with fraud, financial crime and investigations of those, that type of conduct, and how you can conduct those investigations safely and legally while dealing with the other disruptions that we're all facing at the moment, working remotely, although I am in our Sydney office, as is Liam today. A larger part of my practice probably focuses on tracing of proceeds of crime, recovery of stolen assets, and then dealing with the defence of claims once a fraud has been made public. So I will be sharing a few of those lessons from that part of my practice, but like I say, the focus is on the earlier stage, and I'm sharing the lessons with you if only you can avoid having to deal with me in that capacity, help you along the way with that. So that's what I'll be sharing with you today. Thank you.
As an employment lawyer, I very much echo Susanna and Liam's comments about COVID being a fertile ground. People working from home is a norm. Melbourne in lockdown, as you can see. I'm also in lockdown. An enormous financial strain on businesses and individuals mean it's increasingly difficult for employers to exercise the type of supervision and oversight that they're used to. People log in from home, the surveillance technology might not work, their IT systems might be remote. And so what we're concerned about and what we think we'll be seeing is that a lot of these issues are flying under the radar for a lot longer than usual. For this reason, if there's suspicion of fraud or financial crime, it's really important to act quickly. And what we're hoping to take you through today is a series of steps of escalating seriousness to make sure that you're getting on top of these issues as quickly as possible. I should just mention there's a Q&A function in this webinar down the bottom. Please feel free to ask us questions as we go. Otherwise, there'll be time for questions at the end as well.
So what do we mean when we're talking about employee fraud and economic crime? Well, it covers a wide range of conduct. And there are a few examples you can see on that slide. But at its core, it's the use of dishonesty to, again, obtain a financial advantage that, that the person isn't entitled to. So things like creating false documents in order to gain an advantage. They might be invoices, they may be pay slips, they may be anything that would entitle an employee normally to receive funds from the business. Payroll fraud, using credit cards in an unauthorised way. That's what we're talking about when we talk about employee fraud and economic crime. Now, it's not hard to find recent examples that are in the media of this sort of conduct. But what's more hard to discern is the extent of this sort of conduct within the business and within the business community, but also more generally. And there are two industry surveys, I suppose we could call them, that help cast a little bit more light on the extent of this sort of conduct and the risk that it sort of poses to businesses. The first is a PwC survey from this year into crime and fraud, and that's a global survey. And the second is the Australian Institute of Criminology's most recent report, which is based on a survey of public sector agencies and their interactions with fraud. Now, the Australian Institute of Criminology's report found that of the Commonwealth agencies that it surveyed, 25% of them had commenced a fraud investigation in the year 2016 to 2017. Whereas the PwC survey found that 47% of the companies that it surveyed had experienced fraud. Now, that's internal and external fraud, but nonetheless, it's quite a high figure. And they estimated the losses of that 47% to be in the order of $42 billion US. So we're talking about, you know, significant risk to business here. Both reports provided some interesting insights as well into the sort of people that are engaged in this sort of conduct. So the Institute of Criminology's report found that the most common age bracket for the most costly frauds was between 35 and 45 years old. So people in that age bracket were committing the most costly of the frauds. There was an even number of male and female perpetrators of the fraud. And that there weren't any senior management involvement in those frauds. And echoing this, the PwC survey found that 34% of internal frauds were actually committed by middle management. So just some interesting factors to bear in mind.
Thanks, Liam. Look, in some ways, the importance of protecting your business against employee fraud and economic crime speaks for itself. It's self-evident. And while you may have insurance policies that actually cover direct losses associated with economic crime or fraud, are no doubt, as many of you will be aware, often covered with many exceptions, including the fraud crime exception itself. And more importantly, it's very difficult to insure against indirect losses, such as reputational harm or the time and cost of investigating fraud and economic crime internally or externally, and the impact on reputation and morale more generally. The other broader ramification is the risk of coming under the regulator spotlight with the attendant risks of shareholder class actions for those of you which are publicly listed companies, and other regulatory action, and that's reasonably severe and well known. There's the potential, you know, as we know, of large fines for the company itself and for executives. There's the possibility of civil penalty proceedings or damages claims brought by the regulator on behalf of the company and shareholders. There's the possibility even of criminal action against the company and directors. And all that is combined with the scrutiny of, you know, public proceedings and the reputational damage that occurs to the company, loss of trust in its compliance and processes. And I also mentioned, in addition to the risk of the regulator spotlight, companies are increasingly exposed to civil actions by shareholders if they are listed for failing to prevent and adequately disclose fraud and financial crime that they've uncovered. That trend's played out, you know, initially as usual in the United States, but increasingly in Australia, and we've seen class actions in respect of Latent Holdings recently for its disclosures about foreign bribery that have been uncovered. or it's late and inadequate disclosures, as the shareholders say. And in fact, one of the first shareholder class actions related to the Australian Wheat Board, which was a matter that ABL was involved in. So that's a trend that, you know, is only going to continue including in relation to the recent amendments to the regulation of class action funding. And it's not going to go away anytime soon. So it's something to keep on your radar as you're looking at the internal investigation of fraud and economic crime.
Directors' duties are important in this area because they feed into the processes and systems that are put in place to help prevent fraud from occurring in the first place. And there's the potential in the event that there's a breach of those duties for the company to seek compensation under the Corporations Act against directors who have failed to discharge their duties and the losses resulted from that breach. And although there aren't any Australian cases that touch on this, there is a UK decision from 2009, which is quite interesting, that talks about this matter. The case is Lexi Holdings, and in that matter, the managing director had defrauded the company to the sum of £60 million. Two of the non-executive directors, who happened to be related to the managing director, knew that he had passed convictions for effectively fraud, and failed to disclose those to the other directors and to the company's auditors. And the court found that had they done that, the fraud wouldn't have been able to be perpetrated, and found that those two non-exec directors ought to compensate the company for the loss that was incurred. So, you know, the wide-ranging implications of fraud mean that it is so important to take effective action, not only to prevent, but then to effectively respond. And that's what we're going to talk about now. Firstly, the steps that should be taken to try and prevent it, and then what to do where fraud is discovered.
Thanks, Liam. So there's 4 key elements to setting in place the documents and framework to reduce the risk of employee theft and financial crime. But these documents and these processes are also really important in terms of managing allegations or suspicions if they arise, in the way that we're going to recommend today. So the first, as you can see on the slide, is a good employment contract. I'll go through each of these in more detail, but this is the summary. The second is meaningful workplace policies that are clear, people can understand, and are not too prescriptive. I see reams and reams of workplace policies come through my office, and my general recommendation is to keep them tight and keep them targeted, because the employees are more likely to understand and follow them if they can actually read them sensibly. The third is regular and targeted training and monitoring, and that's so you don't have these excellent policies and excellent contracts that just sit in a drawer and your employees aren't aware of their obligations. And the fourth is the creation and ongoing maintenance of a workplace culture that's geared towards detecting issues and an expectation of compliance amongst employees. So to dig into a little bit more detail, a properly drafted employment contract is vital in setting baseline expectations. And if it has some of these key clauses, it also gives an explicit ability to investigate, suspend, and dismiss an employee in the event of misconduct. Now, of course, you can do all of those things without those provisions in your contract, but it makes it far easier and far clearer for an employer if they are in there. So in these situations, there's several key provisions that I look for in employment contracts. The first is a conditions of employment clause, which often requires an employee to go through a police check or a background check or something similar prior to their employment starting. The inclusion of this type of clause for roles with access to financial controls and sensitive information is becoming more common. And if I just go back to the example that Liam gave of that UK case, if they had have done that background check, they would have identified the employee had previous fraud convictions and possibly avoided the entire situation. In addition, it's best practice to ask new employees to disclose any conflicts of interest up front. Of course, you can also ask existing employees to do the same. And an ongoing obligation to disclose conflicts of interest as they arise. This can be done in the contract or in policies. The next is a probationary period, which is a simple and often underutilized way to try out a new employee and assess if there are any upfront concerns. Probationary periods are around 3 to 6 months, which loosely corresponds with the jurisdiction for unfair dismissal claims. A lot of contracts have a probationary period, but what I don't see is many employers actively assessing and monitoring employees during that probationary period and moving quickly if they think the employee is not a good fit for whatever reason. A provision that I'm seeing increasingly in contracts for executive employees is an indemnity provision. Now that can come in a range of different ways. It can be an indemnification for the employer against particular loss, or it can be limited to serious misconduct, can be limited to material negligence, fraud, and the like. Whatever elements those indemnity provisions have, they are very useful in terms of leveraging an outcome in relation to these situations, but also recovering the loss. As Susanna said, often there are gaps in insurance policies, which mean you're reliant on these types of clauses. Although there's a common law right to suspend an employee, it's always easier to have an explicit suspension clause within the contract. This avoids any technical breach of contract claims that an employee might make to try and avoid the suspension or challenge the suspension before you've even got into the body of any investigation. And of course, clear provisions enabling termination of employment, including termination without notice in a range of circumstances. The next stream is workplace policies, which, as I've said, my general recommendation is to keep them tight and targeted. Up on the screen, there's some policies which may touch on the type of issues that we're talking about. I certainly don't recommend all of these. Instead, a lot of these have overlapping obligations, and deal with the same subject matter. I caution particularly against having a prescriptive workplace investigation or disciplinary policy, which is in that list for these discussion purposes only. The more flexibility an employer has in terms of how they run an investigation and how they discipline their employees, the better. And I'll come back to that when we get to that stage of the presentation. Finally, workplace practices and the culture of workplace will often determine whether these types of fraud and crime has the space to occur and the space to go undetected for some time. So some of the things that we see that are effective in this area is regular training on policies and procedures. And that's training to both management and also to employees with a slightly different focus of that training. Obviously, you want to encourage management to have a supervisory oversight. And as Liam said, an alarmingly high percentage of this kind of conduct is committed by middle management. The second is ensuring that there's proper oversight and supervision of employees. So performance management, setting KPIs, checks and balances, financial transactions, unannounced audits. Now that is the element that a lot of my clients are having more difficulty with as people are spread out across their homes and remote access. The use of surveillance technology where appropriate. So this can include IT system alerts when certain funds are transferred or quantums are transferred, monitoring an employee's email or work phone, and the ability to access the IT network and shut off certain access to people. There is prescriptive legislation in each state which differs slightly as to how an employer can monitor an employee's emails, work phone, IT use. And New South Wales in particular has a prior notice obligation. And we typically recommend that's in an employment contract or a policy. But the point I want to make here is caution should be exercised before delving in and accessing an employee's emails. And we'll run through some of the ways that you can trip up later on in the presentation.
So once an allegation has been made, it's important to conduct an investigation. You want to be able to verify the truth of that allegation and use the investigation to decide effectively what scope of steps need to be taken next. This is an overview of the investigation steps, which we'll talk about in more detail. But step one is to engage lawyers and forensic experts, then conduct a desktop review of the allegations to find out whether there's enough to them to take them forward, put the findings of that desktop review in a preliminary report. The preliminary report might identify areas that there needs to be further evidence gathered. Inevitably, that will involve speaking to the employee and then the production of a final report. So there are a couple of reasons why it's important to engage lawyers and forensic experts at an early stage. The first is a concept that many of you will be familiar with, and that is privilege. These sorts of investigations throw up quite sensitive topics. There may be frank assessments of the lack of compliance with policies, or the lack of supervision, or all sorts of things which an organisation understandably doesn't want to be made public, and certainly doesn't want to fall into the hands of a regulator. By engaging lawyers to conduct the investigation, the report that's produced as a result of that will be privileged and will be protected from regulators. It won't protect the underlying material, but certainly the report and the report of an expert that's engaged by lawyers for the purposes of legal advice will be protected by privilege. And the other important reason why lawyers should be engaged in early stage is because they have a network of experts that they've worked with in the past, who they can recommend as the right people for the particular situation that the organisation is facing. The second reason is that these issues often involve complex legal questions. Insider trading, for instance, involves a number of complex questions about material effect on share prices and what a person knew at the time that they were conducting a trade. And so these sorts of things are questions that are best examined and answered by lawyers who have training in this area and experience in dealing with these sorts of topics. And the third reason why it's important to engage lawyers and experts early is because it's important to preserve the evidence that exists that might be relied on in the future in court proceedings, or even just to preserve for the purposes of preparing the report. You don't want to have the findings of the report seek to be impugned because there's an accusation that the evidence wasn't preserved correctly, or there wasn't sufficient metadata that was obtained. Now, organisations often have IT people that you know have got experience with dealing with IT issues, but they may not be trained to capture the evidence in a way that that is defensible in court proceedings, or defensible more broadly. So again, it's important to bring in the right people to conduct those early investigations.
You'll also see the last bullet point on the previous slide refers to consideration of policies, legislation and employee contracts. It's a little bit of complexity and legal risk about immediately shutting off an employee's access to their emails before you've had a chance to formalise those allegations and put it to them. I've touched on the surveillance legislation, but there are ways that you can more discreetly capture the type of evidence that Liam's just gone through. So I've seen forensic experts take a complete image of the IT network at a point in time, shadowing inboxes, rerouting emails, so every email bounces through to a forensic expert to assess. All of those processes can be put in place in the background to assess whether there's an issue and before you raise the allegations with the employee.
So the first step after engaging lawyers or experts is to conduct a desktop review. Now, what a desktop review is, it will be a review on the papers of data that's been prepared by the organisation that may show that the fraud has occurred or some other misconduct has occurred. The benefit in conducting a desktop review as opposed to a full review at this stage is that you want to get a sense of whether or not there's a case to answer. If there is, then the desktop review will identify areas that need to be examined further in order to bottom out those issues. If there isn't, well then the investigation doesn't need to proceed any further. Now, of course, with any advantage, sometimes there are disadvantages, and one of the limitations of a desktop review is that you're not speaking to people, you're not getting the full context behind documents. You obviously haven't spoken at this stage to the employee that's concerned. And so there's some limitations, but if the matter proceeds, if the investigation proceeds, they can be addressed through conducting further inquiries. The findings of the desktop review are usually turned into a preliminary report. As I said, if there's no case to answer, well then the investigation won't proceed, but it's important that that's documented in a defensible way in case perhaps the issue is raised again and there's a question mark over why the organisation didn't take more adequate steps in the past to deal with this. Or you can point to the report and say, well, we did, and there was no evidence to substantiate the allegations. If there is a case to answer, the preliminary report, as I said, will identify areas that further evidence is needed and further work will then be put into preparing that evidence. And what that might look like is conducting searches, perhaps searches of the data set that's been gathered through forensic experts, searches for both evidence that supports the employee's position and also supports the allegation. So you want to be impartial in the way that you go about this investigation. You want to look for evidence both ways. So that might require looking at emails for certain things, looking for patterns of behaviour. In the event of an allegation of insider trading, you might want to look at how the market has responded to certain similar information in the past, work out whether or not that information that the employee traded with would have had a material effect on share price. And you might also at this stage speak confidentially to potential witnesses. But inevitably, you will also need to speak to the employee.
So again, at this stage of the process, employment contracts, policies, or even enterprise agreements might set out certain requirements about how to interview the employee. For example, they might require a certain amount of prior notice to be provided, might enable the employee to bring a support person or a lawyer or a union representative, if they're entitled to see the allegations in writing beforehand, how many meetings must be conducted, etc., etc. And it's for this reason that I circle back and say I don't recommend that there's a comprehensive investigation or disciplinary policy because it might set out things that look sensible at the stage but really limit how the employer can deal with this situation. Within that framework, so let's assume there's no documents which set up a process, there's still obligations in relation to procedural fairness and due process. These are set out on the slide, but in summary, it's important to provide the employee with enough information to enable them to properly respond. You can't just give the allegations in a general sense. You need to give them specifics about what they've said they've done, the date, and your basis for it. Often it's important to provide them with supporting evidence, for example, bank records or IT records, whatever you've gathered in the desktop review and preliminary report stage that Liam has just gone through. If they ask to have a support person present, unless that request is unreasonable, it should be allowed. Of course, an unreasonable request would be having someone else in the business who might be involved in the fraud in that meeting. But most people bring a lawyer who doesn't speak in the meeting or a family member or friend. And the purpose of that meeting is to give them an opportunity to respond to those allegations. Often in this first meeting, employees are shocked and they may not give you much information. So we also recommend that they're given a day or so afterwards in which to provide further information once they've had a chance to think through the allegations. Following this meeting, immediately following this meeting, the employee should be suspended. And that's the most effective way to ensure that they don't tamper with evidence, they don't speak to witnesses, and the investigation stays confidential. Often you only get one shot to meet with the employee before you suspend them. And I often see employees at this stage going on long periods of sick leave, and it's very difficult to get them back into the business. So you should be prepared for this meeting, have all the documents ready, have the letter ready to go afterwards, put all the information to them, because this is the employer's best chance at getting a proper response from the employee. If the employee refuses to attend the meeting, the process can be set up to provide them with another opportunity to respond in writing. And otherwise, the correspondent should notify them that the investigation will have to go ahead without their input. Of course, that's not the preference, because it's always better to get the full story and the context for a couple of reasons. One, if the employee admits it, you might not need to go through the whole investigation process and you can deal with the employee then. Two, the employee might disclose other fraud and financial crimes. If they think they're caught out, they might give a whole lot of information. there was a case in Western Australia recently of someone, a public servant, who they found 2 allegations of fraud, and he admitted to another 20 in the interview process that they wouldn't have found otherwise. As I said, very regularly after this first meeting, once the employee is suspended, they might go on sick leave. If they have accrued sick leave and they have a medical certificate, which employees can get anywhere, local pharmacy, GP clinic, then they would be paid their sick leave during this period. That's fine in theory, but there is a certain urgency to conclude the investigation and not have the employee on a period of sick leave for a long time, especially if they have a significant leave balance. So I've seen situations in the public sector where an investigation has been conducted and the employee has been on sick leave for up to 18 months while the investigation has been completed.
So after all inquiries have been completed, it's important to prepare a final report. And what that report should do is set out each of the allegations that have been made and go through the evidence that supports the allegation and the evidence that doesn't support the allegation, and reach a conclusion on the balance of probabilities. Is it more probable than not that the conduct occurred? Reach a conclusion as to what the employee has done. Now that report will be quite detailed, and as I say, it may have some fairly frank assessments about what has gone on and what should have happened and what didn't happen. And that's again why it's important that these sorts of documents are privileged. The purpose of the report is threefold, really. Well, in addition to concluding the investigation and ascertaining what went on, it might be used as a basis to consider disciplinary action. And though the report shouldn't itself make any findings or recommendations, that should be through a separate process, which Bridget will talk about shortly. The report might also be used to assess whether or not a report needs to be made to the authorities, and we'll talk about that in a short time as well. And then the third is that it might be used to consider commencing proceedings to freeze assets and to recover stolen funds, which is something that Susanna's going to speak about now.
Yeah, thanks, Liam. The process that Liam and Bridget have outlined of the internal investigation and reporting often has to occur in parallel with action that you'll be taking to either freeze assets or seek recovery of any misappropriated funds, and at the same time consider what reporting, if any, needs to be done to regulators. And often there's more than one regulator that you'll need to make disclosures to. And, you know, as we've said before, all of that has to happen with an awareness of the collateral consequences of the disclosures and publicity that's going to arise from many court proceedings, and, you know, what the ultimate resolution in respect to the economic consequences are to your business. So those sorts of decisions have to be made, like I say, while the investigation, unfortunately, is ongoing. Often speed is of the essence, particularly if there is any potential for recovery. Often with these types of allegations of fraud and financial misconduct, the proceeds will have been dissipated, whether they're on gambling or lifestyle expenses or mistresses. I mean, we can see, you know, things like the Plutus fraud recently, where significant amounts of Commonwealth money, you know, were defrauded through a tax scheme. And basically, I think there's very little hope for recovery there, because it all seems to have gone on expensive girlfriends and trips to Dubai. But in any event, you've got to make an assessment as you're conducting the investigation as to whether a recovery is going to be possible and economical, or you know, an effective way of recovery. So the reporting process and the investigation process that Bridget and Leon have outlined, you know, also ties into those court proceedings. If there are suspicions that the employee or the officer is taking steps to dissipate assets or to remove them from the jurisdiction, to avoid liability, then you will need to seek urgent legal advice and consider applying for a court order for urgent relief, and including, for example, search or freezing orders, and they can be targeted not just against the individual and people associated with them or areas where you think those funds might have gone, but to banks and other financial institutions to assist in, for example, putting your foot on assets and bank accounts and tracing where the money's moved to. And the test for freezing orders, and this is something that you need to consider through the investigation process, is whether you've got a good arguable case in respect of a particular cause of action against the employee, and is there any danger that in the event that you went through a full court process and were successful in getting a judgment against them for breaches of their employee duties or breaches of fiduciary duties that they owe to your organisation, whether having gone through all of that, the actual judgment debt that you get at the end would be unsatisfied because the defendant's been permitted to move their assets or diminish the value of them over the length of that process. So while conducting the investigation, it's often important to keep in mind as Liam was saying at the beginning, the evidentiary quality of the information that you're obtaining, ensuring that you have an integrity of the data source that can withstand scrutiny of a court, and often because these urgent applications are made without notice to the other party for obvious reasons, you're going to have them scrutinised quite closely by a judge, so you need to make sure that they can survive that questioning. Basically that the investigation at the same time is conducted with an eye on those types of recoveries if indeed they are available and it's economical to pursue them. The final thing to consider when finalising the investigation report is also, recovery from the insurers. Again, you need to act quickly to the extent that you have a policy that potentially responds to notify the insurers, and the type of notification and the types of claims that can be made need to be considered at the very early stage of the investigation as well. One tip is to consider seeking the insurer's agreement to spending money on the forensic investigation process as well, because that ultimately saves both you and the insurer some time, and the insurer particularly in having to do its own investigation as to whether policies respond. Even if it doesn't necessarily appear to be covered by the policy, and investigation expenses are more common in policies, but still quite tailored to circumstances. It's worth reaching out to your insurer, like I say, at an early stage to see whether they're prepared to assist in funding to the extent you need, for example, external forensics in the investigation process.
So let's assume we've gone through each of the steps and we've spoken to the employee, and it's obvious that there has been some fraud, and now we need to think about the disciplinary process. I sound like a broken record, but this process might be impacted by the employment contracts or policy or enterprise agreement. Let's put those to one side and just go through the procedural fairness and due process aspects of it, which is set out on this slide. So there's really 4 steps. The first is to consider the appropriate disciplinary action and the surrounding factors. So it includes what is the breach of the employee? What breaches have been substantiated? How serious are they? Have there been previous incidences of misconduct? What response or explanation did the employee give you? How long have they been employed? Do you think you can get the funds back? Is the employee apologetic? All of those types of questions need to factor into thinking about whether the disciplinary action is termination or something lesser than termination. It could be demotion, it could be salary reduction, it could be first and final warning, could be training, a range of outcomes available depending on the type of breach. So in this first step, it's important not to finalise the decision before you've met with the employee. So if the employee refuses to meet, so let's remember this, they're most likely on sick leave, they might refuse to come in for this meeting. That's fine. You can set out this information in a letter to them instead. That information would include a summary of the investigation and each of the allegations that have been substantiated. Details of the proposed disciplinary action, the basis for that disciplinary action. So let's say it's termination. You want to set out in the letter the reason why their ongoing employment is completely untenable in the business. And then giving that employee an opportunity to respond, either in person if they turn up to the meeting or in writing. After the meeting, the employer should consider those responses and then make a final decision. Now, although I've set out 4 steps, each of these can happen in a very short space of time. Once a final decision has been made, that should be confirmed with the employee, again, in person if they show up, or in writing if they refuse to. And it will be necessary to work out what you're going to do with that employee going forward. So again, let's assume it's termination. Are you going to terminate with notice or without notice? And if it's with notice, are you going to have them go on gardening leave? Are you going to pay out the notice? Are you going to have them work and do some handover? Let's say if the breaches aren't particularly serious. How does this interact with their bonus and incentive arrangements? Do you have incentive arrangements whereby if there's misconduct, they're clawed back? Are they entitled to some pro rata amount? What's going to happen with their salary going forward? Can you get someone to hand over their role and step into their role, especially if they've got a external responsibility, if they're your accountable person for regulatory reasons or something similar. It's important to make sure that this process is tight and goes through those steps because this is really where the rubber hits the road for employees. They realise that their employment has ended. They realise they're probably not going to get another role. They're certainly not going to get a positive reference. And at this stage, people often get lawyers, try and stop the process, seek urgent injunctions to stop the disciplinary action being implemented, and otherwise cry that there's breach of process or breach of contract or they haven't been afforded procedural fairness. I'm raising that point particularly because in this COVID environment, terminating an employee, it has ramifications that hadn't previously existed. It's unclear when and how they're able to get another role, and it could be a significant period of time that they're unable to get a role. That has 2 consequences. 1, desperate employees often bring legal proceedings. And 2, if they do bring legal proceedings, there's a quantum of damages question in terms of how long it will be until that employee can get a role on similar terms.
One of the main issues of concern that we get from clients, whether they be listed entities or other entities, is the obligation to report and make disclosure and the timing and content of those disclosures, often at the time when the facts are still under investigation or uncertain. As you can see, organisations may be subject to various different regulatory or contractual obligations to report employee fraud and financial misconduct. And so, as we've spoken of, that includes regulators, and there's often more than one. Your insurers, potentially industry bodies, if there are lawyers involved, whether you need to make any disclosures to Law Society and to your shareholders. In respect of listed entities, the ASX listing rules provide that you are required to make disclosure of any information that would be expected to have a material effect on the price or value of your securities. And we've seen, as we've discussed already today, some big shareholder class actions that have been brought where the content and timing of the disclosures that have been made pursuant to obligations under the listing rules has been said to be inadequate. For example, both AWB and the Leighton's recent class actions relate to allegations of foreign bribery in both of those cases, and the claims that have been brought by their shareholders has been that the company breached its continuous disclosure obligations by failing to disclose the actual investigation that was ongoing at the time. In respect of both of them, clearly they were both very, very sensitive. In respect of AWB, it was an investigation bribery of Iraqi officials that ended up being investigated not only by the United Nations but by the World Bank. There were proceedings in multiple countries. In the United States, there were racketeering proceedings that were brought against AWB and Alien Claims Tort Act proceedings. So, the ramifications for that company were extraordinary in respect of the investigation that it was conducting and the things that were being uncovered. At the same time, it ended up facing, like I say, an Australian class action for the timeliness and adequacy of its disclosures to the market. But even for those of you who are not listed, there's often disclosures that are required, whether they are under contracts that you have with state or Commonwealth entities. Anything involving a government tender contract of either description often will have disclosure obligations built into it. And you'll see often, there's more than one regulator to report to as well, unfortunately. We see that often with our charity clients or our clients who have schools where there's fraud. They often have several layers of state and Commonwealth regulators who they need to report to. And there are also other organisations, like I say, particularly in the foreign bribery space, World Bank, Asian Development Bank, who have reporting obligations and significant suspension or cancellation of your ability to contract with those organisations if the disclosures are not seen to be adequate or timely. And all of this has to be considered against the backdrop in the Australian environment, particularly the criminal landscape, which needs to be factored in to the content and timeliness of your reporting. We've got the proposed introduction of deferred prosecution agreements coming in the near future, subject to what happens with our Parliament and COVID. And there are also proposed amendments to the criminal standards that apply to corporates. So for corporate criminal conduct that effectively, in some senses, reverse the onus, require you to prove that you have adequate policies to prevent financial misconduct and fraud. Otherwise, you can be criminally liable. So they are developments that I think are inevitable and will come, shortly, depending on, like I say, Parliament sitting. I've got one instructive example on the ramifications of reporting to share with you, which is one of my current matters. My client is the former chairman of Sinclair Knight Mertz, which is a big Australian multinational engineering firm, construction firm. As part of a due diligence process, it was being taken over by Jacobs, the multinational firm. They uncovered some very minor examples of foreign bribery from the early noughties, around 2000. And because there are allegations that involved a suggestion that my client, as the chairman of the firm, knew about this, and that the Chief General Counsel should have known, both stepped aside effectively for the process of the internal investigation, and that investigation ended up being run by an external law firm. That law firm then reported to both the World Bank and Asian Development Bank, which resulted in some suspension, but more importantly, handed its entirety of its report over to the police in circumstances where, as Liam said, there were sensitive findings in there. Those findings hadn't been tested against, for example, people like my client. And the AFP said, thank you very much, put a ribbon around it and used it as the basis of criminal prosecution. So my client is now facing criminal charges for a conspiracy to be involved in foreign bribery in the amount of $100,000 that allegedly occurred more than 20 years ago on the basis of an investigation where no further investigation was done by the AFP, but the investigation by the expensive law firm brought in by the company to conduct that proceeding and report. And that proceeding is going through the committal process at the moment, and we'll have several years to run. But it's not to dissuade you, but just to say that there are ramifications of reports, and that you need to consider the life that they may have well beyond the purposes that were on the initial slide that Liam showed you that you may be using them for. A final point to make in respect of reporting and disclosure is the need to consider privilege and potential waiver of your legal professional privilege. As we've been saying, independent or internal corporate investigations of wrongdoing often occupy a very grey zone in relation to legal professional privilege, which is dangerous. You will often have frank assessments of conduct or liability or fault, whether they're accurate and properly tested or not. And those internal investigations, if they're conducted internally without external lawyers, may not meet the very high bar that we have for legally for protections of legal professional privilege. So it's just something to be aware of when you're considering how to proceed with the investigation and what to include in the final report. And we can give you guidance about external communications with third parties about your investigation and the ways you can ensure that you don't lose privilege over the material. But just be very wary of that and be aware of the risk of reporting that's prepared for multiple purposes. It's difficult to establish dominant litigation privilege if you've got a report that's prepared for disciplinary purposes as well as for reporting purposes as well as for use in civil proceedings. So there are things to be alive to in the context of concluding the investigation or reporting the findings.
And just picking up on what Susanna said about the criminal ramifications, there's a criminal overlay to reporting obligations in addition to any regulatory or contractual requirements that an organisation may face. There are certain offence provisions in state and territory law which oblige companies and individuals who have material relating to proof of an offence to disclose that to police. But it's a complex assessment that needs to be made on a case-by-case basis. And that's because it depends firstly on the conduct that's been alleged. So, for example, fraud is dealt with. Fraud involving a company would be dealt with at a state level, so there'd be a state offence, and then you need to look at whether or not under that state law there is a requirement to report, whereas corporations offences are dealt with at the Commonwealth level, so you have to have a look at whether there's a Commonwealth obligation to report that matter, and usually there's a threshold for what you need to report, so it turns on the seriousness of the conduct. Usually there's a threshold of a serious indictable offence, which is usually an offence that carries with it either life imprisonment or a term of imprisonment of over 5 years. So if you're dealing with that, and a lot of these sort of frauds and financial crimes come within that level of seriousness, then that's an issue that needs to be considered. Then you need to also have a think about whether or not the organisation has derived a financial benefit from not reporting the conduct. It may be an offence to not report if you are deriving a financial benefit. There's also a carve out for whether or not that financial benefit is in fact compensation for the loss that's been incurred. So there are a few complex questions that need to be worked through. Again, going back to the importance of involving lawyers at an early stage, because these are complex questions that lawyers should really consider and give advice about whether or not there's an obligation to report the matter to police. And it's an important obligation because failing to do so might be a criminal offence.
And that's a criminal offence for the company and senior management as well. And the question of benefit, which does exist in some of the offences, so if you've obtained benefit, including from not reporting, is one that's not being well trammelled, unfortunately, in the case law, and is actually not very well defined in at least two of the statutes that we see it in. But you could see that there is potential breadth of benefits that you might have received. And again, this seems a little bit counterintuitive, but there may be benefits that the company has received from the financial misconduct and or not reporting it. For example, one of the cases that's running in the papers at the moment is the ANZ cartel case. You can see that there could be an allegation that ANZ in fact benefited from the cartel conduct that was alleged to be operating in respect of that IPO. Now, is it benefiting from not reporting? There's some various questions that need to be considered in respect of disclosures that have to be made about that type of conduct if they became aware that there was a Commonwealth criminal offence that had occurred there. Similarly, in insider trading or foreign bribery, you can envisage circumstances in which the company may have itself received a benefit from the particular conduct in question. So it's just something to be alive to, that there are several layers of disclosure obligations that themselves contain criminal offences if they're not properly complied with.
So there are a couple of questions that have come through. Liam and Susanna, I might take this first one because it's in my wheelhouse. So the first question is, what is the position in regard to withholding an employee's entitlements when they're alleged to have carried out a fraud and been terminated, and the alleged sum is greater than their entitlements? Really great question. We get this a lot. The obligation to pay an employee's entitlements, which is accrued annual leave, accrued long service leave, and their notice, unless they're terminated without notice, is an entirely separate legislative legal obligation that can't be deviated from. So even if the employee has defrauded the company, let's say in the sum of $1 million, and their leave entitlements are worth, let's say, $60,000, there is a very clear legislative requirement for the employer to pay out those entitlements. Now, we've seen a range of contracts and policies which purport to offset those amounts. Those provisions are unlawful, and if an employer tries to rely on those, the employee would have a pretty clear claim that the employer has breached the Fair Work Act, and there are civil penalties. So not just judgment not in favour, but the individuals who are involved in not paying those entitlements and the company are subject to pretty severe penalties.
Morning, everyone. My name is Rebecca French, and I'm a senior associate in the workplace advisory team working with Bridget. Another great question that's come through for our panelists is, how early can I suspend an employee if it looks like there is fraud?
Great, that one's for me as well, but there's also another one which is similar. I said to suspend an employee after the first interview. How does the suspension work in practical terms? Are you permitted to do this under workplace policies? Do you continue to pay them and tell them not to come to work and bar their server access? So let me respond to all of those in one. The reason I recommended that they are suspended just after the first interview is because, as I said, that's your best shot at putting the evidence to them, putting the allegations to them and getting their response. Once you suspend an employee, it's often very difficult to get them back in, not just because they go on sick leave. People in the business ask a lot of questions. No one knows where they are. Confidentiality can be compromised. So that's the reason that I do it in that sequencing. Suspension in practical terms, in the meeting with the employee, you say to them, we need to investigate this further. We need to consider your responses. Your employment is suspended as of today. We will let you know when that suspension ends. But for now, you need to go home, not perform any work, not speak to any colleagues, and we're going to suspend your IT access. So not cut off their access permanently, because that's in the realm of when their employment has ended, but you can certainly suspend their IT access immediately. You then also want to think about what you're going to tell the rest of the business about that employee's sudden disappearance. If the allegations and the breaches are not that serious, you can ask the employee what messaging they prefer. For example, they've had a personal issue come up or they've gone on unexpected leave. If the issue is serious and you want to send a clear message to the business, if people ask, other employees ask, you could say, we're conducting an investigation and the employee's not at work at the moment. The ability to suspend an employee is an ability at large under common law, but it can also be an explicit right under a policy or a contract, which is why I kept referring back to those terms. But if you don't have those explicit provisions, you can still suspend an employee. In relation to continuing to pay them, that's a slightly complicated question. Our general advice is yes, continue to pay them during suspension. There are a small number of situations where that won't be appropriate, but by and large, the legal risk of not paying them far outweighs the money you will spend paying them while the investigation is conducted. Now, I caveat that on the basis that the investigation is running quickly and efficiently, and you've gone through at least some of the steps that Liam, Susanna, and I have outlined today. If you're in a situation like one of my clients, as I've outlined, where they had a number of people suspended or on sick leave for in excess of 12 months, of course, you want to revisit whether you're going to pay during that suspension and have a think about how you're going to deal with those particular employees if the investigation is taking a long time. I think that's all the elements of the suspension question, but please write in if I missed something.
I think that's it, Bridget. Good morning, everyone. Gisela DeCosta from Workplace Advisory. I work with Bridget and Rebecca. Bridget, Liam and Susanna, I've noticed over the years that this is one workplace issue that really overwhelms employers. Receive many calls with employers, from employers who are in a panic. They feel they don't have the luxury of time. They feel that they're under pressure from business owners, from management to get the employee out ASAP. And this really seems to be reflected in a lot of the questions that we've received today, namely, do you have to go through every step in the process which has been outlined? It seems a bit long.
Perhaps I can answer that, and Susanna, feel free to chime in. Well, what we've outlined is best practice. If you don't follow all those steps, there's a risk that your investigation process may not be as easily as defendable as if you did. So obviously it's important to put the allegations to the employee in order to respond. If you don't do that, well then they're going to say that they weren't given a procedural, they weren't afforded procedural fairness, sort of similar to what Susanna was saying in her case. And the findings of the report aren't reliable, they're skewed, the documents were taken out of context, and it really casts doubt over how accurate the report is and how much reliance ought to be placed on it. In terms of dealing with things quickly, of course, we appreciate the importance of resolving issues and dealing with them in a speedy fashion. And that's where the desktop review really comes in order to provide a more immediate response as to whether or not the allegations have legs, and then taking the necessary steps. But it is important to go through the process so that the investigation, the findings of the report can be defended if needed.
I'll let Bridget answer if there's any further implications from a workplace perspective of not following through the steps, but really the only thing I have to add to Liam's answer is to say, you know, of course, in some senses, this is often governed by commercial questions and the economics of it, and, you know, the scope of the fraud. It's useful to understand, you know, precisely what you're dealing with, and often that can only occur once you've gone through those steps. I've got a current case that's running through the courts at the moment where we initially thought the matter related to just 1 year of ATO refunds. Turned out, which we thought was about $1 million, then we thought it was about $4 million, and now we've found 3 or 4 different MOs, and it's worth $7.5 million in terms of misappropriated funds. So, you know, a lot will depend on the scope and the economics in terms of whether it is commercially viable to pursue anyone for it, and the extent to which you need to make sure that you've got integrity of your evidence to withstand court proceedings or to convince banks to freeze accounts. So that's sort of from the litigation perspective, but Bridget may have something to offer from a workplace perspective as well.
No, I think that's covered. The point I made earlier is that during this period, employees are far more likely to challenge the process and the steps that you've gone through, because the ramifications of termination in this COVID environment are far more significant.
Just picking up on something that Susanna said about, you know, uncovering further fraud. Before coming to ABL, I worked at the Commonwealth DPP, and I prosecuted fraud matters. And if it's one thing I learned from there, it's that people don't usually commit one fraud. Fraudsters commit a lot of fraud. And usually if you found one example, there are other examples to find. And that's why it's important to conduct a thorough review to make sure that you've captured all the fraud or other economic misconduct that's occurred. Well, I think that's all the questions that we have. If there's anything else that you'd like to speak to us about, feel free to reach out and contact us on our details there. Always happy to speak about these matters with you. But if we don't speak again, I hope you've I hope you've enjoyed the presentation, and that it's been useful and practical, and we hope you've had a good morning.
Thank you, everyone.
Stay safe and keep washing your hands.